Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Jake Blake, an Ohio construction lien law expert. Today's webinar topic is don't sign a release unless it says this one thing. So without further ado, I'd like to introduce the fabulous Jake.
Thank you for the introduction. I'm not sure about fabulous, but I'll take it. You know, I've been asked to do a couple of these for SunRay now, and hopefully I'm able to provide a little bit of context. Obviously, we don't have a lot of time to go into tremendous detail regarding any of the subjects. These are more meant to be appetizers. By all means, this is not meant to provide all of the information that you could possibly require or need when you run across a situation with a waiver or a release. Hopefully what you can get out of this is enough to know when you need some extra help, and folks like me are available when those circumstances arise. So here we go. Don't sign a release unless it says this one thing. I guess I'll start with this title is a bit of a misnomer because really you've got about 4 different kinds of releases. And so what I hope we can do by the end of this webinar is you'll be able to identify what type of release you should be signing and to make sure that you're doing that, just that. Because I think, most releases are similar in what they do and what they achieve, and I'm sure anyone listening to this has been required to sign some sort of lien waiver in connection with their pay applications or receiving payment from a contractor or owner. But I think that the issues can arise depending on when you sign the release and what kind of release you sign. So we're going to take a look at that. Here's a little material for you from SunRay. You can use your chat box if you need to ask questions, and we'll get to those questions at the end. And if you can, try to sterilize what you're asking a question about as much as you can, anonymize. We don't want to know company names and things like that. All right, so here's the agenda. Pretty simple slides. We're going to talk a little bit about what your contract can or can't do with regard to lien waivers. We're going to talk about the different kinds of waivers, unconditional versus conditional, final versus progress. We're going to provide some examples of fairly generic clauses, but that'll help us identify what kind of waiver we are signing and why. And then we'll just briefly talk about some other traps and pitfalls to be aware of. And then SunRay has some of their materials that they'd like to share. So your contract, and I've got the little sub bullet under Johnny, I hardly knew ye. And that's because in your initial contract, you can actually waive all of your rights before you even get paid or provide any materials or even ask to get paid. And that's because Ohio does not regulate the form or language of its lien waivers. They don't regulate the timing of lien waivers. In a lot of states, Alabama, for example, it's illegal, meaning the law has prohibited contractors or owners from requiring ahead of time lien waivers. But this is the wild, wild west in Ohio. We don't restrict that at all, and so it could actually be part of your initial terms that you're already waiving your rights to a lien before you even start work. And so pay attention to your contracts. And I say this all the time: read your contract again, and then read it again, because you don't want to be in a situation where you're not getting paid and you go and file your lien, and lo and behold, your contract, you've already waived those rights. And so this isn't necessarily one thing in don't sign a release unless it contains this one thing. This is more, initially know whether or not you even have the right to a lien. And if you do come across a contract that requires you to waive your lien rights ahead of time, I found that those are generally negotiable. Generally, parties will budge on that or provide some other accommodation. But that might be a time when you need an attorney to help negotiate your contract for you if you run into that situation. All right, these are really the four different kinds of liens. When you talk about unconditional and conditional, final versus progress, right? You can have a lien waiver for final. You can have one for progress, and it can be conditional or unconditional. We're going to talk about the differences. So this is what I was talking about at the outset, where we wanted to use the right form at the right time. And so an unconditional waiver and release on final payment should, number one, be used at the end, right? When you're getting paid, whatever balance is left on the contract for the work or materials provided. And if it's unconditional, that means that you're waiving it without any conditions whatsoever. And so you should only do an unconditional waiver if you've already received the money. That's why we referenced show me the money on the first slide of this section. So if you haven't received the money, you should never sign an unconditional waiver and release on the final payment. Now, if you haven't received the money, what type of waiver should you sign? Well, that's easy. That's a conditional waiver. And we're going to look at some examples, but the conditional waivers typically include language that says something to the effect of, this waiver is conditional upon receipt of payment in the amount of, and then you'd write the amount in there that you're requesting. Again, you can have a conditional or unconditional for a final payment. And then now we move to the progress payments, and this is the same thing. You would only sign an unconditional waiver for a progress payment if you've already received the money. And then for a conditional waiver, you would simply say, again, what we talked about for the final payment, the waivers or releases contained herein are conditioned upon receipt of money in the amount of. And that way, if you submit your lien waiver and you end up not getting paid, you still have the right to file your lien, even though you've technically waived such right in the waiver. And even when I'm representing contractors or owners, and I put in these, either the prime contract or my subcontract agreements, I almost always use conditional waivers. They're just cleaner. They don't require. Well, typically I don't get any pushback if I have a conditional waiver in my contract, and I find them they're just more fair, right? You wouldn't want to put someone in a position where they're forced to sign a waiver that is final and unconditional if there's a chance that there wouldn't be money involved. And the other reason why I use the conditional waivers is a lot of times the clients I represent, owners or contractors, don't want to pay the money prior to receiving the waiver. And so I find the conditional waiver to be a far better instrument to use in these circumstances. All right, here we go. Here's some examples as promised. And there's the altered Allen Iverson quote, for those of you who remember that from probably 15 years ago at least. But we're talking about progress payments, not a final. And here we are, unconditional waiver and release on final payment. The language in these, and again, this is about the most generic waiver or release that you can find. And just so everybody's on the same page, I'm sure everybody is, right? What you're doing with these waivers generally is exchanging them for payment. Funds won't be released until you sign the waiver, or if you are paid, you're required to waive. And what you're waiving is your right to lien the property for non-payment for services or materials. And so that's exactly what these documents do. This language, right, waives and releases, essentially all claims for the labor and the service provided. And it even incorporates whatever change orders that have been fully executed by the parties. And then once it's signed by the claimant, and the claimant is the person claiming the right to be paid, so that's you all generally in this circumstance, they're waived and released by this document unless listed as an exception below. We can talk about exceptions in a second, but the key language I want you to look at here is at the very end, and I put it in bold. The claimant has been paid in full. And like I said before, you never want to do an unconditional waiver unless you've already been paid. And that's exactly what this says. The claimant has been paid in full. And so if you were to sign one of these unconditional waivers and you had not yet been paid, and then it turns out that you don't get paid, you would not have the right to lien the project. That right would be gone. And if you did so, you would be potentially setting yourself up for a cloud on the title, meaning the owner or the contractor could sue you for interfering basically with their ownership rights for putting a cloud on the title to the property. So be very, very careful when you see this type of language. The claimant has been paid in full. When you see that, it's imperative that that is actually true. It's past tense. You have been paid. And here's the conditional waiver. And so see how this is different? This says the language before is all about the same, but it says this document is effective only on the claimant's receipt of payment. Right? So there's a precondition to the effectiveness of the waiver and release. So if you sign one of these and you haven't been paid, no problem, right? Presumably there's something in the contract or the terms that require you to submit this waiver and release along with your pay application. And once you do so, you will be paid. But if something happens and you're not, you still have not waived your right to put a lien on the project. And that's what the conditional waiver is meant to do. All right, let's talk a little bit about progress payments. So progress payments differ a little bit, and really there's two things you want to focus on when you're talking about progress payments. Like before, you want to know if it's an unconditional or conditional waiver, right? You want to know if, and you should know that if you've received payment, then no problem signing an unconditional waiver. By the way, if you've already received payment and they give you a conditional lien waiver, that's okay too. But the real key is don't sign an unconditional waiver unless you've already been paid. And I'll say that 100 more times. But then when you're talking about progress payments, you want to make sure it's not a final. You want to make sure that there are bumpers on what you're being waived, what is being waived. You only want to waive work and services that you're requesting payment for. So it's not the entire project unless you're at a final. It's whatever additional work has been performed since your last pay application. And the way you typically do that is by saying work performed through a certain date. And you can designate the date on the waiver. And And then you usually designate the amount or the services that have been provided. Sometimes if you're using a continuation form on an AIA document, that's the G703S. If you're a subcontractor, you're specifying out exactly what work or materials was provided, and you're requesting payment for that material, or you've been paid in an unconditional waiver. You've been paid for that work, and and you're waiving then your right to lien based on that work. But you still should be maintaining your right to lien future work. And here's the conditional version of the progress payment. Again, it contains that same through date of this document language, which I've highlighted. And then at the end, it contains that language we looked at before. This document is effective only on the claimant's receipt of payment. And as I said, these are my preferred tools, are the conditional waivers. They're just cleaner from a timeline perspective and from a risk to waiving something you're not intending to waive. All right, other traps and pitfalls, and quoting Fleetwood Mac there. Pay attention to the through date. We talked a little bit about that. You don't want to put in the wrong date. You don't want to inadvertently waive stuff that has not occurred yet. Again, because in Ohio, it's the wild, wild west. You can through either just through inattention, you can end up waiving far more than you wanted to waive. To notarize or not to notarize, Ohio doesn't have a notary requirement. Some states do, but Ohio does not. Again, which frankly could potentially lead to further issues, because it's easy to waive. It's easy to sign, execute, and provide these waivers, since you don't really need to go through the notary step. And then typically the waiver forms I use, and most of the generic ones you'll see, include a section for exceptions. So if you're at a part of the project where some amount is in dispute, there's some acceleration costs, or the material increased, and you're not under some sort of guaranteed maximum price situation, you and the contractor or the owner are in a dispute as to how much is owed for a certain part of the work. Well, you can still request payment for the undisputed amounts, and depending on what your contract says, there may be different tools on what to do with the disputed amounts. But it's important on your waiver to note exceptions, because if you are in a fight or a dispute over the amount of money that should be paid for materials that were delivered, you only want to waive your right to lien on the amount that is not in dispute. Because if you simply just say in your lien waiver that you're waiving the right to put a lien on materials, on certain materials that have already been delivered, you might unintentionally end up waiving your right to lien on the dispute. Now, you'll still be entitled to sue or trigger some other dispute mechanism to recover those monies, but you'll just lose your lien rights, which, as everybody knows, is one of the strongest tools you have at your disposal in these kinds of disputes. All right, I know that we have some questions here, but we also have some of these SunRay resources, and I think there was at some point some of these include a quiz, but it looks like that quiz was removed from this version, which is okay. I was just going to simply ask everybody different scenarios about whether it's an unconditional or a progress lien waiver, and I'll just pose it to the group and you can think about it. But if you're in a scenario where you have not been paid and you are requesting a progress payment during, before all of your work or materials have been delivered, what is the proper type of lien waiver to use in that circumstance? And the answer is obviously a conditional progress payment lien waiver. Okay, any questions? If not, I'll turn it back over to Jesse.
First of all, thank you so much, Jake. We really do appreciate it. That was some great information about distinguishing between unconditional and conditional. That's always helpful. We do have a couple of questions that have come through. And I think you've already touched on this one. It says, is there anything I can do if I mistakenly sign an unconditional release and the funds are bad?
So the answer to your question is yes, there are lots of things you can do. Again, what you're waiving and releasing is not the right to sue. It's not what you're waiving and releasing is your right to lien the project. And so you will always have remedies at law if you've been promised money and that money does not come. There's a but here. This is why it's so important to pay attention to whether or not this is conditional or unconditional. And let's say that you've received a check and then that check bounces. Okay, I would not sign a conditional or an unconditional waiver or release until that check clears. So don't get caught in the trap where an owner or contractor puts a big check in front of your nose and says, okay, you've received the funds, now sign this unconditional waiver. I would say I need 7 days or however long it takes for that check to clear before I sign this waiver. And if they try to force you to sign it, that would be very suspicious to me. Very suspicious.
All right, and that kind of ties into the next question that was posed. It was asking, what if a GC says you must sign this unconditional release in exchange for the check? Is there anything you can legally fight against that? Or is that just a business decision and you need to weigh the pros and cons? Or is there any reason that would be appropriate?
No, so it would never be appropriate for a contractor to force you to sign a unconditional waiver before receiving the funds, or before you have the time to verify that the funds are received. That would never be appropriate. Now, I understand the situations that contractors can put subs in, and frankly, I found sometimes that contractors in that scenario don't even really know what the form says. Some attorney or some project manager 10 years ago put together their general or their master subcontractor agreement, and they're like, hey, here's a lien waiver I downloaded offline, and they're just using it, and they might not even understand that they have an unconditional waiver. And so the first thing I might do is say, do you understand that what you're asking me to do is acknowledge that I have received the funds? And I can't make that acknowledgement. That would be a lie, right? That would be untrue. And so, I think maybe explaining to them what the issue is might be your first step. If they understand that and they still nonetheless force you to sign or want you to sign a waiver, that might be a time for you to reach out to an attorney.
Okay, wonderful. Thank you so much for that. That's all the questions that have come through. If anyone does think of a question that wasn't addressed, please feel free to reach out to us. I'll be sure to answer any questions as soon as possible for you. Are you able to go back on our slideshow just so we can give them that QR code for our resources, Jake? One more, I believe. Perfect. All right, so here are some of SunRay's resources to help you guys stay organized, know your deadlines, secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Remember, each state has its own unique lien laws that are only specific to that state. So check out on our website. You can select which state you're working in, what your role is on that job, and it will list out what documents you need to be sending and what those deadlines are. So please check it out. You can use these project information sheets. They're really wonderful. They'll help you get some of the information right at the beginning of your job to know who's working on the project upstream from you, so that way you can better prepare yourself. All right, next slide, if you don't mind, please. All right. If you don't mind, give us a review on Google. We really do appreciate it. It helps us get the information out to other contractors and suppliers like yourselves, but it also helps us understand what other topics you potentially would like to hear about and learn about. So please give us that review. We really do appreciate that. And then the final slide, if you don't mind, please, Jake. All right, so that's all we have for you guys today. Thank you guys again for attending today. We hope to see you guys at our next webinar. Jake, I really can't thank you enough. You really are wonderful. So thanks again, everyone. I hope you all have a wonderful and beautiful sunny day. Thanks, everyone. Bye.
Thank you.